What happened in the congressional hearing room yesterday left Supreme Court Justice Brett Kavanaugh visibly stunned and the entire legal community buzzing. Congresswoman Jasmine Crockett delivered a constitutional argument so precise and powerful that it changed the course of a high-profile Judiciary Committee hearing in just under 3 minutes. A routine oversight session transformed into one of the most remarkable constitutional confrontations in recent memory when Kavanaugh attempted to lecture the Congresswoman on First Amendment jurisprudence. With all due respect, Congresswoman, these are complex constitutional matters that require significant legal expertise, Kavanaugh said with unmistakable condescension after Crockett had questioned the consistency of his recent opinions. The committee room fell silent, everyone present sensing a pivotal moment. What followed was a masterclass in constitutional interpretation that not even the most seasoned justice was prepared to counter. If you're tired of seeing qualified women of color dismissed despite their expertise, you won't want to miss what happens next. Hit that like button and subscribe, because Jasmine Crockett's response didn't just leave Kavanaugh speechless, it exposed contradictions in the Supreme Court's recent jurisprudence that legal scholars will be discussing for years to come. To understand why this confrontation has sent shockwaves through America's legal establishment, you need to know who these two figures are and why this clash represents far more than a momentary exchange. If you're finding this analysis valuable, take a second to hit that like button and subscribe to our channel. We bring you in-depth breakdowns of crucial moments in American governance that mainstream media often glosses over. Your support helps us continue this important work. Supreme Court Justice Brett Kavanaugh, 59, has served on the nation's highest court since his contentious confirmation in 2018. With his Yale law education and background on the D.C. Circuit Court of Appeals, Kavanaugh positioned himself as a textualist and originalist in the mold of Justice Scalia. His opinions have largely aligned with the court's conservative majority, particularly on issues involving executive power, religious liberty, and free speech. Since joining the Supreme Court, Kavanaugh has cultivated an image of measured judicial temperament, working to distance himself from the heated emotions of his confirmation hearings. In public appearances, he frequently emphasizes the importance of constitutional principles and the need for the court to remain above partisan politics. The congressional oversight hearing, where this confrontation occurred, focused on the court's recent First Amendment decisions, particularly cases involving protest rights, campaign finance, and religious expression. These decisions have generated significant controversy, with critics arguing they represent inconsistent application of constitutional principles depending on the ideological valence of the case. Congresswoman Jasmine Crockett, now in her second term representing Texas, brings a completely different background and perspective. Before entering Congress, Crockett built an impressive career as a civil rights attorney and criminal defense lawyer. A graduate of the University of Houston Law Center, she earned recognition for her work challenging voting restrictions and representing protesters whose constitutional rights had been violated. Since joining Congress, Crockett has quickly established herself as one of the most legally knowledgeable members of the House Judiciary Committee. Unlike many representatives who rely heavily on staff for legal analysis, Crockett regularly demonstrates a detailed command of case law and constitutional principles during hearings, drawing on her extensive courtroom experience. What wasn't widely known before the hearing was that Crockett had recently completed an in-depth analysis of the Supreme Court's First Amendment jurisprudence over the past 5 terms. Her research, conducted in partnership with constitutional scholars from several leading law schools, identified troubling patterns in how the court applied supposedly neutral principles differently depending on the subject matter and parties involved. The stage for the confrontation was set when the Judiciary Committee scheduled an oversight hearing on Supreme Court decision-making and constitutional interpretation. Such hearings are rare, as justices typically avoid testifying before Congress except during confirmation. However, amid growing concerns about court legitimacy and calls for ethics reform, Kavanaugh and 2 other justices agreed to appear. When Chairman Jim Jordan announced that each committee member would have 5 minutes for questions, few expected that Crockett's turn at the microphone would produce one of the most remarkable exchanges in the history of court-Congress relations or that her constitutional expertise would leave a Supreme Court justice visibly struggling to defend his own jurisprudence. The House Judiciary Committee hearing room was filled to capacity, with additional spectators watching on screens in an overflow room. The atmosphere was tense but formal as Justice Kavanaugh finished responding to routine questions from several senior committee members about the court's procedures and decision-making process. When the chairman announced, "The gentlewoman from Texas, Miss Crockett, is recognized for 5 minutes," Kavanaugh shifted slightly in his chair, perhaps expecting another round of general inquiries. Crockett, dressed in a crisp navy suit with a Constitution-themed lapel pin, organized her notes methodically before beginning. "Thank you, Mr. Chairman. Justice Kavanaugh, I appreciate your appearance today," she began, her tone professional and measured. "I'd like to focus specifically on the court's application of First Amendment principles across different contexts. In your concurrence in Americans for Prosperity versus Bonta, you wrote that consistency in constitutional interpretation is essential to the rule of law. Would you say that remains your position?" Kavanaugh nodded, seemingly comfortable with the opening question. "Yes, Congresswoman. Consistent application of constitutional principles is fundamental to the court's legitimacy and the rule of law." "I couldn't agree more," Crockett replied. "With that principle in mind, I'd like to examine how the court has applied First Amendment standards in different contexts over the past 3 terms. She opened a binder containing case excerpts. In Bonta, which involved disclosure requirements for charitable donors, you joined an opinion finding that even indirect burdens on association rights trigger strict scrutiny. Yet in McKesson v. Doe, involving protest organizers, the court permitted potential liability for others' actions under a much lower standard. Could you explain the constitutional principle that justifies this different treatment?" Kavanaugh shifted in his seat, clearly not expecting such a specific comparison. "Those cases involve different First Amendment contexts, Congresswoman. Donor privacy implicates association rights in a distinct way from protest activity." "But Justice Kavanaugh," Crockett pressed, "both cases fundamentally involved the same First Amendment right. Freedom of association. In Bonta, the burden was disclosure of information to state regulators with confidentiality requirements. In McKesson, the burden was potential financial ruin for organizing a protest where someone else broke the law. Why would the former trigger strict scrutiny while the latter receives minimal protection?" The room grew quieter as attendees realized they were witnessing not just routine questioning but a substantive constitutional challenge. Kavanaugh's expression shifted from mild surprise to visible concentration. "The specific contexts and government interests differ significantly," he offered. "The court's jurisprudence recognizes that First Amendment principles apply differently across varying factual scenarios." "Different applications, certainly," Crockett nodded. "But shouldn't the underlying principles remain consistent? Let me point to another example." She turned to a different tab in her binder. In Kennedy v. Bremerton School District, you joined the majority, finding that a public school coach had the right to engage in visible prayer at school events. The court emphasized that even potential indirect coercion of students was too speculative to limit this expression. She continued without pausing. Yet in City of Austin versus Reagan National Advertising, decided just months earlier, you joined an opinion permitting significant restrictions on sign content because of speculative aesthetic and safety concerns. Both cases involve balancing expressive rights against speculative harms. Yet the court applied entirely different analytical frameworks. What constitutional principle explains this discrepancy? Kavanaugh's discomfort was now evident to everyone in the room. "Congresswoman, these are complex constitutional questions that require detailed analysis of precedent and context. I don't think they can be reduced to simple comparisons." Crockett maintained her professional demeanor. "I'm not suggesting simplistic comparisons, Justice Kavanaugh. I'm asking about the consistent application of constitutional principles, something you yourself have emphasized is essential to the rule of law." She turned to another document. "Let me be more specific. In Americans for Prosperity, you wrote that history and tradition must guide First Amendment analysis. Yet in Kennedy, the majority largely dismissed historical practices regarding church-state separation in public schools. The opinion instead emphasized modern conceptions of religious expression. How do you reconcile these different approaches to history and tradition in First Amendment cases decided in the same term? The committee room was now completely silent. Several legal reporters were frantically taking notes, recognizing that Crockett was raising substantive inconsistencies that constitutional scholars had identified but that rarely get addressed in congressional hearings. Kavanaugh, appearing increasingly uncomfortable, responded, "With all due respect, Congresswoman, these are complex constitutional matters that require significant legal expertise." The condescension in his tone was unmistakable, and it proved to be a critical error. Several committee members glanced at each other, recognizing the dismissive implication that Crockett lacked the legal expertise to engage with these issues. Crockett paused, her expression unchanged. "Justice Kavanaugh, before joining Congress, I litigated constitutional cases for 15 years, including First Amendment claims that reached the Fifth Circuit. I'm quite familiar with how constitutional principles should work in practice." Without raising her voice or changing her professional demeanor, she continued, "The question isn't whether cases have different facts, of course they do. The question is whether the court applies consistent analytical frameworks regardless of the identity of the speakers or the ideological valence of the speech. The evidence suggests it does not." She then proceeded to demonstrate her point with remarkable precision, placing two Supreme Court opinions side by side on the display screen. In these two opinions, both authored within the past 2 terms, the court applied strict scrutiny to protect religious speech while applying rational basis review to nearly identical secular speech. The constitutional text makes no such distinction. Crockett then referenced specific passages from Madison's writings on the First Amendment and early Supreme Court jurisprudence. The original public meaning of the First Amendment, which you've emphasized as controlling, offered no hierarchy of protected speech. Religious and secular, conservative and progressive speech were entitled to the same protection. Yet the court's recent decisions have effectively created preferred categories of expression. The scholarly precision of her analysis was now evident to everyone in the room. This wasn't political grandstanding, but a substantive constitutional critique grounded in text, history, and precedent, the very interpretive tools Kavanaugh himself championed. Kavanaugh attempted to regain control of the exchange. "Congresswoman, the court strives for consistency, but each case presents unique." "Justice Kavanaugh," Crockett interjected politely but firmly, "I've identified 7 major First Amendment cases from the past 3 terms where the court applied completely different levels of scrutiny to government actions that impose similar burdens on speech. The only consistent pattern is the ideological direction of the outcome, not the constitutional analysis." She displayed a chart showing these cases with their holdings and level of scrutiny applied. When conservative religious speech is at issue, the court consistently applies strict scrutiny. When progressive political speech or workers' rights are at issue, rational basis or intermediate scrutiny suddenly becomes appropriate. This is not consistent constitutionalism. It's outcome-driven jurisprudence. The scholarly rigor of her presentation was undeniable. Even Republican committee members were watching intently, several nodding despite their political differences with Crockett. Constitutional analysis of this caliber transcended partisan lines. Furthermore, Crockett continued, "Your own writings before joining the court emphasized that neutral principles of constitutional interpretation must remain neutral regardless of the subject matter. Yet the court's recent First Amendment jurisprudence shows precisely the subject matter discrimination you once criticized." As her questioning continued, Crockett methodically identified specific inconsistencies in the court's recent decisions, always returning to Kavanaugh's own stated principles of interpretation. Her command of constitutional doctrine and Supreme Court history was evident in every precise citation and carefully framed question. The dynamics in the hearing room had completely shifted. What began as routine oversight had transformed into a masterclass in constitutional analysis by someone clearly fluent in the highest levels of legal reasoning. Kavanaugh, initially confident and slightly dismissive, now appeared genuinely challenged by the substance and precision of Crockett's critique. The confrontation reached its climax when Crockett opened a final binder and looked directly at Kavanaugh. "Justice Kavanaugh, I'd like to discuss something specific in your own jurisprudence that illuminates this issue." Before your confirmation, you wrote extensively about the importance of viewpoint neutrality in First Amendment analysis. In your Harvard Law Review article from 2012, you stated that the cardinal sin of First Amendment jurisprudence is treating similar speech differently based on the identity of the speaker or the popularity of the message. Kavanaugh's expression changed to one of surprise. Few members of Congress were familiar with his academic writings from before his judicial career. "I'm familiar with my article, Congresswoman," he said cautiously. "I'm glad to hear that," Crockett replied. "Because I've analyzed all 23 First Amendment cases decided since you joined the court. In cases involving religious speakers, corporate interests, or conservative advocacy groups, you voted to apply strict scrutiny 100% of the time. Yet in cases involving protesters, labor organizations, or civil rights groups with identical constitutional claims, you applied intermediate or rational basis scrutiny in 91% of cases." The room was completely silent as Crockett continued. "This pattern directly contradicts the principle you articulated in your Harvard piece. It suggests that the determining factor in your First Amendment analysis is not the constitutional text, history, or precedent, but the identity of the speaker and the ideological content of their message." She then placed side-by-side quotes from two of Kavanaugh's opinions on the display screen. In these two opinions, written just 4 months apart, you applied completely different analytical frameworks to nearly identical government restrictions on speech. The only meaningful difference was the identity of the speakers and the content of their message. Kavanaugh, visibly flustered, adjusted his tie. "Congresswoman, judicial opinions address the specific cases before the court. Different contexts require different analyses." "Different contexts, certainly," Crockett acknowledged, "but different constitutional principles. Your own writings emphasize that while applications may vary, the underlying constitutional principles must remain consistent regardless of who is speaking or what they're saying." She paused, then delivered the defining moment of the hearing. "Justice Kavanaugh, the First Amendment doesn't protect only popular speech or powerful speakers. It doesn't have a carve-out for certain ideological viewpoints. The same constitutional principles must apply whether the speaker is a corporation or a protester, a religious organization or a labor union. When the court applies strict scrutiny to protect speech it favors while applying minimal scrutiny to speech it doesn't, it undermines the very neutrality that legitimizes judicial review." Kavanaugh, clearly unprepared for this level of substantive critique, attempted to pivot. "The court strives to apply constitutional principles even-handedly, Congresswoman. Reasonable minds can differ on specific applications." "Reasonable minds can certainly differ," Crockett replied, "but principles shouldn't differ depending on who's speaking. That's the essence of viewpoint neutrality, a concept you've championed in your own writings, but that your voting record on the court has not consistently reflected." Several phones in the gallery were now raised, capturing what was clearly becoming a historic exchange. Legal reporters from major publications were typing frantically, recognizing that this wasn't merely political theater, but a substantive constitutional critique with significant implications for First Amendment jurisprudence. Kavanaugh shifted in his seat, his legendary composure visibly cracking. "Congresswoman, you're conflating different lines of First Amendment precedent to create an appearance of inconsistency." "I'm not conflating anything, Justice Kavanaugh," Crockett replied calmly. "I'm directly quoting your opinions and identifying their internal contradictions. For example, in Americans for Prosperity, you wrote that even minor burdens on association must survive strict scrutiny. Yet in Cedar Point Nursery, decided that same term, you joined an opinion applying rational basis review to a significant burden on labor organizing, which is also a form of association protected by the First Amendment." She turned to another document. "And let's discuss your repeated references to history and tradition in First Amendment cases. In Kennedy, you joined an opinion that virtually ignored the long historical tradition of limiting school officials' religious expression. Yet in Bonta, you emphasized historical practice as determinative. The principle seems to apply differently depending on the case." The committee chair glanced at the clock and signaled that Crockett's time was almost expired. Crockett nodded in acknowledgement and delivered her final points with surgical precision. Justice Kavanaugh, I respect the court as an institution and your role within it. What I question is the inconsistent application of constitutional principles based on who is speaking and what they are saying. When the court applies strict scrutiny to protect speech it favors while applying minimal scrutiny to speech it doesn't, it undermines the First Amendment's core purpose, protecting all expression regardless of its popularity or the power of the speaker. She looked directly at Kavanaugh. The greatest threat to First Amendment freedoms isn't any particular restriction on speech. It's the perception that constitutional protection depends on who you are and what you're saying rather than the nature of the government action. If the court wishes to maintain its legitimacy as the guardian of constitutional rights, it must apply its interpretive methods consistently, regardless of the identity of the speaker or the ideological valence of the speech. The hearing room erupted with murmurs. Several committee members, including Republicans known for their respect for legal scholarship, were nodding. Journalists were frantically taking notes. Kavanaugh sat stunned, clearly unprepared for such a precise and substantive critique of his constitutional jurisprudence. A senior Republican committee member leaned over to his Democratic colleague and whispered, "I disagree with her politics, but that was a masterclass in constitutional analysis. She just exposed real inconsistencies in their recent decisions." Chairman Jordan, recognizing the historical significance of the moment, said, "The gentlewoman's time has expired, but the witness may respond to her points." Kavanaugh, gathering himself, said, "The court strives to apply constitutional principles consistently across all cases. What may appear as inconsistencies often reflect the complex interplay of different lines of precedent and the unique facts of each case. I appreciate the Congresswoman's perspective and her obvious preparation for today's hearing." His response, while professional, noticeably failed to address any of the specific contradictions Crockett had identified. The Supreme Court justice, known for his detailed and articulate opinions, had been rendered essentially speechless by precise, substantive questioning from a congresswoman he had attempted to dismiss as lacking legal expertise. As the hearing moved to the next questioner, cameras caught several senior committee members approaching Crockett with evident respect. A veteran Republican congressman who had clerked on the D.C. Circuit was overheard saying, "That was the most substantive constitutional analysis I've seen in this committee in 20 years. The aftermath of the Crockett-Kavanaugh exchange was immediate and far-reaching. Within hours, video clips of the confrontation had gone viral across social media platforms. #constitutional clash and #Crockett schools Kavanaugh became trending topics nationwide, with the exchange generating over 30 million views in just 24 hours. Legal scholars from across the political spectrum weighed in on the substance of the exchange. Harvard Law professor Lawrence Tribe tweeted, "In 50 years of constitutional law, I've rarely seen such a precise and substantive challenge to the court's First Amendment jurisprudence." Congresswoman Crockett identified genuine inconsistencies that deserve serious engagement from the court. Even conservative legal figures acknowledged the significance of her critique. Former federal judge J. Michael Luttig wrote, "While I often support the court's recent First Amendment decisions, Congresswoman Crockett's analysis of inconsistent scrutiny standards raises legitimate concerns about the principled application of constitutional doctrine. Her questioning was remarkably substantive and deserves serious consideration." Major news outlets quickly moved beyond reporting on the personal dynamics of the exchange to analyzing the substantive legal issues Crockett had raised. The New York Times published an in-depth examination titled, "A Tale of Two Scrutinies: The Court's Divergent Approaches to First Amendment Claims." The article extensively quoted Crockett's analysis and noted that many constitutional scholars found her identification of inconsistent standards persuasive. CNN assembled a panel of First Amendment experts who largely confirmed Crockett's analysis. "What made this exchange so remarkable," said one prominent conservative legal scholar, "was that she wasn't making political points. She was identifying genuine jurisprudential inconsistencies that many of us have observed, but that rarely get addressed so directly in congressional hearings." Within days, law schools across the country requested permission to use video of the confrontation in constitutional law courses. Georgetown Law Center announced a symposium titled Scrutiny and Consistency in First Amendment Jurisprudence, inspired directly by the issues raised during the hearing. The Yale Law Journal commissioned a special issue examining the scrutiny disparities that Crockett had highlighted. For Justice Kavanaugh, the hearing represented a significant professional challenge. Court watchers noted that his dismissive response to Crockett's initial questions, followed by his inability to substantively address her critique, damaged his reputation as a principled jurist. The Washington Post published an analysis titled, Kavanaugh's First Amendment Jurisprudence Under Scrutiny, examining whether his voting pattern indeed showed the inconsistencies Crockett had identified. Legal blogs and forums were filled with discussions of what many were now calling the Crockett test, whether a justice applies the same level of constitutional scrutiny regardless of the identity of the speaker or the ideological valence of the speech. Law professors reported that students were beginning to apply this analytical framework to evaluate Supreme Court decisions across various constitutional provisions. Within the Supreme Court itself, sources suggested that the exchange had prompted internal discussions about doctrinal consistency. According to court insiders who spoke anonymously to The New Yorker, several justices had privately acknowledged that Crockett's analysis had identified real tensions in the court's recent First Amendment jurisprudence. Even some conservative justices were reportedly concerned about the perception that constitutional protection varied based on the identity of the speaker. There's a sense among some justices that this exchange exposed vulnerabilities in the court's approach to First Amendment cases, one source told The New Yorker. When a member of Congress can identify such clear patterns of inconsistent scrutiny, it raises questions about whether the court is truly applying neutral principles of constitutional interpretation. For Congresswoman Crockett, the hearing transformed her national profile. Law schools across the country invited her to speak about constitutional interpretation and congressional oversight. The American Constitution Society asked her to deliver a keynote address at their annual convention on neutral principles and First Amendment jurisprudence. Major legal organizations representing women and minorities highlighted her performance as evidence of the importance of diverse voices in constitutional dialogue. The National Bar Association established a Jasmine Crockett Prize for Constitutional Analysis for law students who demonstrate exceptional ability to identify inconsistencies in constitutional doctrine. What Congresswoman Crockett demonstrated wasn't just individual brilliance, said the Dean of Howard Law School in a widely shared editorial, but the value of perspectives from those who've actually litigated constitutional claims for everyday Americans. Her practical experience as a civil rights attorney gave her insights into the real-world consequences of doctrinal inconsistency that purely academic perspectives often miss. Perhaps most significantly, the exchange changed how Congress approached its oversight role regarding the Supreme Court. Legal commentators began discussing what some called the Crockett model of congressional questioning, focused on substantive constitutional analysis rather than political talking points or personal attacks. A Pew Research poll conducted 2 weeks after the hearing showed that 71% of Americans believed Supreme Court justices should be required to explain apparent inconsistencies in their application of constitutional principles. Most notably, these views crossed partisan lines, with majorities of both Republicans and Democrats supporting greater doctrinal accountability from the court. 3 months after the hearing, the impact continued to reverberate when the Supreme Court heard oral arguments in a major First Amendment case involving protest rights. Court observers noted that several justices, including Kavanaugh, asked questions specifically addressing the consistency of scrutiny standards across different types of speakers, questions that directly echoed Crockett's critique. When the decision was announced 4 months later, legal scholars were surprised to see Kavanaugh's concurring opinion, which took pains to address the consistency of First Amendment doctrine across different contexts. While not citing Crockett directly, his opinion acknowledged that the court must be vigilant in applying consistent standards of scrutiny regardless of the identity of the speaker or the popularity of the message, a core principle of First Amendment jurisprudence that must guide all of our decisions in this area. Justice Kavanaugh's jurisprudential evolution on First Amendment consistency is remarkable, wrote a constitutional law professor in SEOTU's blog. His current emphasis on viewpoint neutrality and consistent scrutiny represents a notable shift from his previous opinions. While justices rarely acknowledge the influences on their thinking, this evolution suggests that principled critique from co-equal branches can indeed impact constitutional jurisprudence. 6 months after the hearing, when Crockett introduced the Judicial Transparency and Consistency Act, requiring the Supreme Court to explicitly identify and justify the level of scrutiny applied in constitutional cases, the bill gained surprising bipartisan support. Several conservative legal organizations endorsed the bill as promoting principled constitutionalism and judicial restraint. For everyday Americans, particularly those from backgrounds traditionally underrepresented in legal institutions, the Crockett-Kavanaugh exchange became a powerful symbol of how expertise and preparation can overcome assumptions and stereotypes. Social media filled with comments from young women of color expressing inspiration at seeing someone like Crockett hold one of the nation's most powerful legal figures accountable through sheer constitutional knowledge. Watching Congresswoman Crockett break down complex constitutional inconsistencies showed me what's possible when you truly master your field, wrote a first-year law student in a viral TikTok video. She didn't raise her voice or get emotional, she just systematically exposed the contradictions in their reasoning using their own words and principles. 1 year after the hearing, the Georgetown Law Journal published a comprehensive study of the Supreme Court's application of scrutiny standards across different categories of First Amendment cases. The study, which confirmed many of the patterns Crockett had identified, has since become required reading in constitutional law courses across the country. As for Justice Kavanaugh, while he never directly acknowledged the impact of the exchange, court watchers noted a distinct evolution in his approach to First Amendment cases. His subsequent opinions showed greater attention to consistent application of scrutiny standards, with one law professor observing, Kavanaugh's current First Amendment jurisprudence shows a heightened awareness of the need for principled consistency across different categories of speakers, a significant shift from his earlier opinions. The confrontation between Crockett and Kavanaugh ultimately transcended a momentary exchange to become a case study in constitutional accountability and the importance of consistent principles in constitutional interpretation. Law schools now teach it as an example of effective congressional oversight and the value of substantive constitutional dialogue between branches of government. Perhaps the most lasting legacy came in the form of a new constitutional law casebook, which featured a chapter on scrutiny standards that began with an account of the exchange. The chapter concluded, "This incident reminds us that constitutional interpretation is strengthened, not weakened, when it faces rigorous scrutiny from co-equal branches. When justices are challenged to explain apparent inconsistencies in their application of constitutional principles, the resulting dialogue enhances the legitimacy of the court and the coherence of constitutional doctrine." If this story of constitutional expertise and principled analysis inspired you, hit that like button and subscribe for more content that shows how knowledge and preparation can speak truth to power. Share your thoughts in the comments about other moments when substantive expertise has advanced our constitutional dialogue. Because when we understand our rights and demand consistent protection of them, we all become stronger citizens of our constitutional republic.